Hello guys. Today we'll discuss the changes that have been brought in the Bharatiya Nyaya Sanhita 2023 as compared from the old criminal law, that was Code of Criminal Procedure. So let me make it very clear that it is not within the scope of this video itself that we discuss each and every nuance and the concepts of this entire subject. So we'll not be delving into the details, rather this will be a mere enumeration of the changes and alterations that have been brought forth. The purpose of discussing such changes is merely to uh, empower you and allow you to understand which type of questions would be asked in the preliminary examinations of judicial services and assistant prosecution officers, and maybe certain other exams as well. Anyhow, let us begin with our discussions. And to begin with, first of all, we'll discuss chapter number 13, which in common parlance deals with the investigation. All right. So if all of you could please open your Bear Acts and mark it along with me, that will be more than fine, I believe. So chapter number 13, which deals with informations to the police and their powers to investigate. In it, the very first section which is dealt here is section 173, which deals with information in cognizable cases. We'll see that a concept or notion of zero FIR has been introduced in the letter of law itself. Zero FIR was already existing, but if you go through the words of section 173, you'll find a phrase has been used irrespective of the area, and by use of this phrase itself, zero FIR has been introduced in the Bharatiya Nyaya Sanhita. Furthermore, if we see section 173 clause 1 subclause 2, which is an entirely new provision which has been introduced. It says that by electronic communication, it shall be taken on record by him on being signed within 3 days by the person giving it. By the virtue of this, by electronic communication, use of the phrase by electronic communication, it becomes clear that FIR could be lodged electronically as well. Anyhow, a rider has been provided in it, and that rider is that after providing the information electronically, the informant must go to the police station within 3 days and sign the document. All right. So what is important for us is by electronic communication itself, and it has to be signed within 3 days. So these are the facts and figures which become all the more important for our examinations. Then again, moving on, if you see section 173 clause 2, you'll see that copy, earlier what happened in CrPC, that the copy was to be given to the informant only. Copy of the FIR was to be given to the informant only. Now another person has been added who is to be supplied with a copy of the FIR, that is the victim. All right. Earlier, victim was not there, so kindly underline it, that the informant or the victim. Moving on to the next change that has been brought forth, it is section 175 173 clause 3, and it is an entirely new provision which has been introduced. Earlier, all of those who have gone through CrPC, you must have heard about the landmark judgment of Lalita Kumari. In Lalita Kumari's case, preliminary inquiry was talked of. All right, and that preliminary inquiry has been introduced as a letter of law, within the Bharatiya Nyaya Sanhita, and it has been incorporated within the ambit of section 175 clause 3. If you go 173 clause 3, I beg your pardon. If you go through the language of section 173 itself, uh, you'll notice that in case of any information regarding a cognizable offense which is punishable with punishment of imprisonment of 3 years or more but less than 7 years, that is equal to 3 years or more than 3 years but less than 3 years, then in those circumstances, in those instances, the SHO with the prior permission of the officer not below the rank of deputy superintendent of police. All right, it is to be noted that the permission must be taken from the deputy superintendent of police, and who will be considering, who after considering the nature and gravity of the offense itself, he may permit the SHO to proceed to conduct preliminary inquiry. And then again, this preliminary inquiry is not without a time limit. It is not as if you can conduct preliminary inquiry in place of the investigation itself. So what happens is that of course you'll first have to take permission from a deputy superintendent police officer of the rank of deputy superintendent of police, and this preliminary inquiry should be done within the ambit of 14 days. All right. What could be the object of introducing such provision? It is merely to isolate all the frivolous or petty and trivial or certain irrelevant matters where the time and resource of the police is not wasted. And that is why duty has been imparted upon a superior officer in the form of DSP or any equivalent, that he must apply his mind, and after considering the nature and gravity of the offense itself, may permit preliminary inquiry if needed. All right. Now we move on to the next alteration that has been brought. Please go to section 173 clause 4. Section 173 clause 4 talks about yet another provision which existed earlier within the ambit of CrPC as well. Nevertheless, it was not written in black and white, and to merely ease the procedure itself, it has been encapsulated within BNSS as clear as a day. You'll see that earlier in CrPC, if a person went to the SHO to register a FIR, and for instance, if SHO refused to register the FIR, then he had a recourse under section 154 clause 3, I believe. He had recourse that he could write a letter and send it by post to the superintendent of police, and if he could not get a recourse from there as well, then that person or the informant had the option to go to the magistrate. Now it has been merely written in section 173 clause 4 itself. If you see the very last line of section 173 clause 4, it says that failing which such a grieved person may make an application to the magistrate. All right. So an application to the magistrate has been expressly allowed in this instance. All right. Now let us move on to the next change, which is under section 174. Section 174 talks of information as to non-cognizable cases and investigation of such cases. All right. Under section 174 clause 1 subclause 2, we'll see that change has been brought, that the NCR in case of non-cognizable report, Uh, the daily diary report must be sent to the magistrate fortnightly. Fortnightly means every 15 days. That is, every 15 days, the investigating officer or the SHO has to forward uh, the daily diary report to the nearest magistrate, and by doing that, it imparts a sense of responsibility upon the police and the investigating officer in case of non-cognizable offenses as well. So it is a welcome provision in this regard, uh, with context to facilitation of justice. Now, moving on to the next change, uh, it is brought in section 175. All right, section 1. So let us see section 175, which deals with police's power to investigate cognizable cases. Let us see section 175, clause 1, proviso. All right. Within the proviso, it is written that, provided that considering the nature and gravity of the offense, the superintendent of police may require the deputy superintendent of police to investigate the case. All right. You see that what is happening here? The superintendent of police, that is SP of any district, he can direct the deputy superintendent of police to investigate any offense. So what could be the object behind behind directing a DSP rank officer or a DSP to investigate any offense? It's the most obvious explanation is that the watching the gravity or the serious nature of the offense, a senior or a more experienced police officer is asked to investigate the case. So it is merely in order to facilitate effective delivery of justice in a swift manner. All right, and it is to be noted that the SP will not do it based upon his whims and fancies. Rather, he must consider the nature and gravity of the offense itself. All right. Now let us see the next change, which is section 175, clause 3. In section 175, clause 3, earlier, if you have gone through CrPC earlier, the provisions of affidavit, as I had discussed, that in case of refusal of registration of FIR by the police, you could go to you could seek recourse in front of the superintendent of police, and even if you could not get a recourse there, you could go to the magistrate. And while you were applying to the magistrate, you had to file an affidavit along with it. All right, but this concept of affidavit was not expressly provided in the CrPC. There was a very famous judgment called Priyanka Srivastav. For all those who have gone through CrPC, they must have heard about the same. By virtue of that judgment, the application which was to be given to the magistrate was to be supported by affidavit itself. And now all these entire provisions have been encapsulated within the ambit of section 175, clause 3. All right. Then again, let us talk about section 176, which talks about the procedure for investigation. And if we see section 176, clause 1 and its second proviso, all right, in the second proviso, certain alterations have been brought forth. You will see that provided further that in relation to an offense of rape, the recording of statement of the victim shall be conducted at the residence of the victim or in the place of her choice, or as far as practicable by a woman police officer in the presence of her parents or guardian or near relatives or social workers of the locality, and such a statement may also be recorded through an audio video electronic means including mobile phones. All right, so the major alteration which is brought is that such statements could be recorded via the means of audio video electronic methods. And specifically, it has been specifically demarcated that audio video electronic means including a mobile phone, all right, because the entire setup of audio video electronic video recording equipments and gadgets could not be carried with the police officers at each and every moment of time. But mobile phone being a basic necessity these days, it could easily be garnered, and that is why it has been categorically demarcated that mobile phones, any video recorded in a mobile phone would also be considered as an evidence of equal value in this context. All right. So these changes that we have discussed so far, it is quite clear that these are very practical changes, all right, and it applies an approach which facilitates procedural ease. Then now we'll talk about section 176 clause 2. It is a mere procedural change in this section, quite similar to what we have discussed earlier. Here in this case, if the police is not investigating any matter, then the daily report must be sent to the magistrate in that case as well, all right. Even if you are not investigating the matter, you'll have to send the daily diary report fortnightly to the magistrate himself. So what does section 176 clause 2 say? In each of the cases mentioned in clause A and B, that is proviso to section 176 clause 1, first proviso, clauses A and B, all right. Proviso subsection 1, the officer in charge of the police station shall state in his report the reason for not fully complying with the requirements of the subsection by him, and forward daily diary report fortnightly to the magistrate, and in the case mentioned in clause B of the said proviso, the officer shall forthwith notify to the informant, if any, in such manner as may be prescribed by rules made by the state government. All right. So it is merely a procedural change that you'll have to inform the magistrate fortnightly about any of the developments in that case as such. Now let us talk about yet another change which is provided under section 176 clause 3. It is more of a what should I say, a structural change, a very positive and a welcoming change. However, it is being a structural change, I believe that it will take a lot of time and political willpower on behalf of our governments. So what does clause 3 include? So it provides that if information is provided pertaining to any offense which is punishable with imprisonment of 7 years or more, in all those cases, in all those instances, the forensic expert has to visit the crime scene to collect forensic evidence. If you have seen much of the Western movies and dramas, you'll see that forensic experts and a team of CSIs are quite frequently asked to collect forensic data from crime scenes, and they are available in the very first instance itself. Unfortunately, due to certain structural lacunas and lack of resources available, we have not been able to impart that thing appropriately in our criminal justice system. Anyhow, I believe that it is a very positive infrastructural change. And in this regard, we'll have to note that the offense must be punishable with 7 years or more. Forensic expert team has to visit in order to collect forensic evidence, and along with that, videography of the entire process must be done. All right, and that videography may be done by any electronic device, and by mobile phone as well. And beyond that, all the state governments have been given 5 years to comply with this provision. So all the state governments are not forced to incorporate it within their criminal justice system at once. Rather, they have been provided with ample time of 5 years to develop a proper system, develop a cadre of such officers, and then put them to the task. All right. So section 176 clause 3 has been done, and now let us see section 179. All right. What does section 179 deal with? It deals with police officers' power to require attendance of a witness, which is equivalent to section 160 of the Code of Criminal Procedure. So there has been a slight change, and rather important change if we talk about the prelims exam, from the prelims exam point of view. What is the change brought here? That male person under 15 years or above 60 years, or women, or physically or mentally disabled, or a person with acute illness, they are not to be called to the police station to record their statements. All right. Earlier, what is the difference here? Earlier, male person below 15 years was the same, but above 65 years was used, and that 65 years has been reduced to 60 years, and yet another phrase has been added, that is a person with acute illness. All right, person with acute illness was not used in CrPC. So for us, what are the prominent changes under section 179 clause 1 proviso? That any person above 60 years of age shall not be usually asked to come to the police station to record his statements, and any person with acute illness shall be allowed the same favor. Okay. Now if we talk about section 179 clause 1 proviso 2, what does proviso 2 talk about? Proviso 2 is a new addendum to the entire scene. It talks that proviso 1 talks about that those persons, if they are not capable to visit the police station, they shall not be forced to come to the station. Proviso 2 provides an instance where the person is willing to come to the station. All right, so there is no bar upon such persons coming to the police station to record their statement. So 179(1) proviso 2 talks that if they are willing to attend, willing to come to the police station, then they shall be allowed to do so. And if you note that all these are mere procedural alterations, and everything is quite coherent in this regard. All right. Okay, now let us move to the next change that has been done here. Section 183. All right, section 183, which is quite similar to section 164, if you remember, 164 of CrPC, which was recording of confessions and statements. All right, so recording of confessions and statements have been talked of under section 183 here, and certain changes have been brought forth here. The very first change is in clause 1 itself. It provides that any magistrate of the district in which the information about the commission of an offence has been registered. So this entire phrase is a new phrase. All right, all of those who are well acquainted with the provisions in CrPC would remember that earlier judicial magistrate and metropolitan magistrate were the only ones who could record statements and confessions. Now what the term has been used is any magistrate. Furthermore, under section 164 CrPC, there was no bar of jurisdiction. A magistrate of any place could have recorded that statement and confession. But if we look closely at section 183, we will find that any magistrate of the district in which the information of the commission of an offence has been registered. All right, so The jurisdiction of the magistrate who could record the confession in a statement has been limited merely to the district in which the information regarding the offense has been recorded. All right. So these are quite important changes that you should note. Now we'll talk about section 183 clause 6 subclause A. All right, section 183 clause 6 subclause A, and in it the very first proviso. What does first proviso provide? It says that in case of victim of sexual offenses, the statements that are to be recorded must be done by a woman magistrate, and in case a woman magistrate is not available, then by a male magistrate in the presence of a woman. All right. So the first requirement is that in case of sexual offenses, the statement or the confession shall be recorded by a woman magistrate. Anyhow, if woman magistrate is not available, then it can be done by a male magistrate in presence of a woman. So this is the basic premise of first proviso. Now we'll talk about section 183 clause 6 subclause A, second proviso. All right. The second proviso talks about that any of the offense which is punishable with 10 years or more, imprisonment of 10 years or more, then the magistrate shall record the statement of witness brought before him by the police officer. So in case of much graver offenses, the magistrate is bound to record the statements of the witness that police has brought forth. And the very basic object is that if you record the statement of a witness, then the witness will not be able to alter his statements later on during the trial process. So this also is done in order to facilitate effective delivery of justice itself. All right. So with this, we are through section 183 as well. There are certain other changes within the scope of this chapter as well, but looking at the time of this video, I believe that for today this data is sufficient. Let me also tell you that a number of people, students, are very much disturbed by the fact that these changes have been brought. So rest assured that these changes are not brought for you alone. It has been brought for one and all. So if it is a problem for you, it is a problem for everybody else as well. So don't worry about that. Rather, keep going on, keep pushing. Underline in the bare acts, if possible note it down, and then continuously revise it, again and again revise it, and I'm very sure that within a very short span of a couple of months you'll feel that you're as capable as anybody else in this paper. Thank you.